All rise, veuillez vous lever. The International Criminal Court is now in session. Lord John to Court Panel International at 08. Please be seated. Veuillez vous asseoir.
Thank you very much. Good morning. Bonjour à toutes et tous. Would the court officer please call the case?
Thank you, Madam President. The situation in Uganda in the case of the prosecutor versus Dominic Ongwen. Case reference ICC 0204 0115. And for the record, we are in open session.
My name is Judge Luz del Carmen Ibáñez Carranza. I am the presiding judge in the appeals arising from the case of the prosecutor versus Dominic Ongwen. My fellow judges comprising the full bench in this appeal are Judge Piotr Homansky, Judge Solomi Balungi Bosa, Judge Rein Alapini Gansu, and Judge Gocha Lorkipanitse. The hearing will be held in the presence of 4 of the judges of the bench due to unexpected health issues of Judge Piotr Homansky, who is unable to join us today. Nevertheless, the full bench has unanimously decided, in the interest of justice and the interest of the parties, to proceed with the delivery of its judgment as scheduled. May I ask the parties and participants to introduce themselves for the record, please, starting with the defense.
Good morning, Honors. My name is Chief Charles Achaleke Taku. Appear today with Thomas Obof, who is present here, Gordon Chifude, who is present, and remotely, my distinguished friend, Bev Lyons, Abigail Bridgman, and Morgan Ashley. And Mr. Wang is present in court, Your Honor.
Thank you. The Office of the Prosecutor, please.
Présenté aujourd'hui par moi-même, Mandia Aignan.
Represented today, the Office of the Prosecutor is represented today by myself, Madame Mignon. I am a senior prosecutor,
Hélène Brady.
and I have
J'ai aussi
Hélène
les
Brady
substituts
with me also,
Reinhold Galmetzer,
prosecutor,
George
Reinhold Galmetzer,
Mugwanya, Priya
George Mugwanya,
Narayan, Matteo Costi,
Piyadarshu Narayanan,
Cross,
Matthew
et le
Cross,
substitut adjoint
Matthew Costi,
Niveda Tiro.
and Niveda Tiru.
Pour ceux qui avaient plaidé le dossier, Madame
As regards those who
Maricel
actually presented the
Reguet aussi
case,
en faisait partie.
Ms.
Elle
Maricel
présente
Reguet
ses excuses
was on that team, and she would like to express her apologies for not being able to attend today. Now, Your Honour, I would like to take advantage of this opportunity also to greet the defence and Mr. Dakou, notably, who has been a colleague at the international courts and tribunals for some 20 years now. I would also like to greet the representatives for the victims.
Thank you very much. Now the legal representatives of victims, please.
Good morning, Madam President, Your Honours. In this proceeding, victims are represented in two groups. I am the common legal representative. My name is Paulina Massidda, and I am the only one attending the hearing for the team of the common legal representative.
Good morning, Madam President, Your Honours. With me in court, James Manguira, Joseph Manova from Kampala, Ato Listowell from Gulu, and Priscilla Alling from Kampala, and myself, Francisco Cox.
Thank you very much. And for the record, I note that Mr. Ongwen is also present in the courtroom. The Appeals Chamber is delivering its judgment today on the appeal of Mr. Ongwen against the decision of Trial Chamber 9 on 4th February 2021, by which he was convicted of 61 crimes comprising of war crimes and crimes against humanity. I will refer to this decision on the Trial Chamber as the conviction decision. Before summarizing the Appeals Chamber's findings on the appeal against the conviction decision, please note that the only written judgment and not this summary is authoritative. The judgment will be notified to the parties and participants shortly after this hearing. I will now begin with a brief account of the procedural background of this appeal. This case concerns Mr. Dominic Ongwen alleged conduct as a high-level member of the Lord's Resistance Army, hereinafter LRA, that pursued an armed rebellion against the government of Uganda, and in particular, the civilian population living in northern Uganda between 1st July 2002 and 31st December 2005. As noted by the trial chamber, while the evidence presented during the trial and the factual findings made in the conviction decision focused on events which took place in northern Uganda between 1st July 2002 and the 31st December 2005, the LRA had been active since 1980s, and the related conflict in northern Uganda has spanned over 4 decades. The LRA, including Mr. Ongwen, perceived the civilians living in the northern Uganda as being associated with the government of Uganda. In particular, those who lived in the government-established internally displaced person camps, hereinafter IDP camps. The IDP camps were the result of an anti-insurgency strategy adopted by the Ugandan government to remove the population from rural areas where it might assist the rebels. A significant number of crimes committed by the accused relate to attacks carried out against some of these camps, in particular the Lukodi, Abok, Pajule, and Odek IDP camps. As acknowledged by the trial chamber, Mr. Ongwen himself was abducted by the LRA in 1987 as a young child and experienced much suffering in his childhood and youth. However, based on the charges, the trial chamber focused on crimes committed by Mr. Ongwen as an adult and as a battalion commander of the senior brigade in the LRA. On the 4th February 2021, Mr. Ongwen was found criminally responsible and convicted of 61 crimes, comprising both crimes against humanity and war crimes. In particular, he was found responsible as an indirect perpetrator of crimes committed in the context of the attacks carried out on the Lukodi IDP camp or on about 19 May 2004, and the Avok IDP camp on or about 8 June 2004. He was also found criminally responsible as an indirect co-perpetrator of crimes committed in the context of the attacks on the Payule IDP camp or on about 10th October 2003 and the Odek IDP camp on or about 29 April 2004. The crimes committed within these 4 attacks included attacks against the civilian population, murder, torture, enslavement, pillaging, destruction of property, and persecution. Mr. Ongwen was also convicted as an indirect co-perpetrator for sexual and gender-based crimes, including the crimes of forced marriage as a form of other inhuman acts, torture, rape, sexual slavery, and enslavement, and the crime of conscription of children under the age of 15 years and their use in armed hostilities. Furthermore, Mr. Ongwen was found to be criminally responsible as a direct perpetrator of a number of sexual and gender-based crimes, including the crimes of forced marriage as a form of other inhuman acts, torture, rape, sexual slavery, enslavement, forced pregnancy, and outrages upon personal dignity. For these crimes, the trial chamber imposed a joint sentence of 25 years of imprisonment. On the 20 May 2021, the defense filed its notice of appeal, and on 21st July 2021, its appeal brief. In the defense's appeal against the conviction decision, the defense raises 90 grounds of appeal, alleging legal, factual, and procedural errors that, in the defense's view, materially affected this decision, and the requests that the appeals chamber reverse all the convictions and enter a verdict of acquittal. The present appeal contains novel and at times complex issues with which the appeals chamber has been required to address for the first time. These include the assessment of grounds of excluding criminal responsibility, namely the affirmative defenses of mental disease or defect and duress, and the interpretation of the elements of certain sexual and gender-based crimes, in particular forced marriage and forced pregnancy. Furthermore, this case concerns an accused person who was abducted by the LRA at the age of 9 years, indoctrinated, trained, and forced to carry out and participate in criminal acts in the LRA. Mr. Ongwen's abduction as a young child and his early years spent in the adverse and extremely violent environment of LRA brought to him great suffering. La Chambre d'appel
interpretation from
a
French.
décidé d'inviter
The Appeals Chamber
amici
decided to
courrier
invite 19
participer
amici
à la
courrier
procédure
to participate in
en
these
raison de leurs
proceedings
connaissances
in light of their
spécialisées
expertise
et de
and
leurs grandes
high
compétences
qualifications
sur
on some
certaines
of the
questions
novel issues
nouvelles
arising
soulevées dans
in the
cet
appeal.
appel. Pour compléter les
And this in
écritures
addition to the
reçues des
submissions
parties
which the
et des
Chamber had received
représentants
from the
légaux
parties
des
and the
victimes.
legal representatives of the
Lors
victims.
d'une audience tenue en février
At a hearing of the Appeals
2022,
Chamber
elle a donné aux
convened
parties et
in February
participants
2022,
dont
the
certains amici
parties and
courriers
participants,
invités,
including
la
certain invited
possibilité
amici
de
courrier,
présenter
were afforded an
oralement
opportunity to
leurs
make oral
arguments
submissions
sur
on
les
the issues
questions
at stake.
examinées. Considering the defense's many grounds of appeal and taking into account their presentation and the overlap between them, the Appeals Chamber has decided to structure its analysis in its judgment and group the grounds of appeal as follows. The Appeal Chamber has first addressed the grounds of appeal, raising a number of alleged violations on Mr. Ongwen's right to a fair trial and other inhuman rights violations, and those challenging specific evidentiary assessments and findings made by the trial chamber. It has been addressed the defense's challenge to the trial chamber's findings of Mr. Ongwen's individual criminal responsibility as an indirect perpetrator and as an indirect co-perpetrator with respect to the crimes committed during the attacks carried out on the 4 IDP camps that were mentioned earlier, and the crime of conscription of children under the age of 15. The Appeals Chamber has then addressed the defense's submissions related to the trial chamber's findings concerning sexual and gender-based crimes, followed by those concerning the grounds of excluding criminal responsibility, i.e. mental disease or defect and duress, pursuant Article 31(1)(a) and D of the statute, respectively. Finally, the defense's submissions concerning the issue of cumulative convictions are addressed. First, alleged errors concerning Mr. Ongwen's right to a fair trial and other inhuman rights violations and other alleged evidentiary errors. In the first part of its appeal brief, the defense raises under several grounds of appeal a number of alleged violations of Mr. Ongwen's rights, which, in its view, were committed throughout the proceedings. In its submissions, these violations made a fair trial impossible and resulted in the legitimacy of the judgment in this case being compromised. The defense mainly alleges, first, errors in the conduct of the Article 56 proceedings, which took place in the early phase of this case. Second, errors in the procedure in which Mr. Ongwen entered a plea of non-guilty. Third, violations of the accused's rights to be informed promptly and in detail of the charges under Article 67(1)(a) of the statute. And four, that the trial chamber expanded the scope of the charges. 5, that the trial chamber failed to provide Mr. Ongwen with relevant translations of documents into Acholi, the language he fully understands and speaks. 6, that the trial chamber discriminated against Mr. Ongwen due to his alleged mental disability. And 7, that the trial chamber failed to explain the outcome of its evidentiary rulings. While all grounds of appeal raising fair trial issues are fully addressed in the judgment, for the purposes of this summary, only some of the main allegations and the related findings will be recalled. Under grounds of appeal 1 to 3, the defense raises procedural legal evidentiary issues with respect to the Article 56 proceedings before the single judge of the pretrial chamber. The purpose of these proceedings were to elicit testimony of several witnesses in the context of a unique investigative opportunity. With regard to the main issue raised by the defense concerning the propriety of the judge's concurrent involvement in the taking of testimony under Article 56 of the statute and the conduct of confirmation proceedings, the appeals chamber finds that there is nothing in the applicable law to suggest that a judge of the pretrial chamber who has participated in a unique investigative opportunity should be excluded from subsequent proceedings in the pretrial phase. On the contrary, all these procedural steps are part of the same pretrial phase, of which the same pretrial chamber is in charge. Under its fourth ground of appeal, the defense contends that Mr. Ongwen's fair trial rights were violated by the trial chamber's failure to ensure, pursuant Article 64(8)(a) of the statute, that he understood the nature of the charges against him and proceeded to trial on an illegal plea of not guilty. The defense asserts, inter alia, the lack of a full Acholi translation of the confirmation decision at the time of the plea contributed to his lack of understanding of the nature of the charges at the time of entering a plea. The appeals chamber finds that in circumstances where the operative part of a confirmation decision defines the acts that an accused person is alleged to have committed, and the legal characterization given to such acts includes the mode of liability charged for each crime, and is provided to an accused in a language that he or she fully understands and speaks, a further translation of the reasoning underpinning such decision and any related separate or dissenting opinions in a language that the accused fully understands and speaks may not be essential to place an accused on notice of the charges in order to enter plea pursuant under Article 64(8)(a) of the statute. One of the main arguments raised under grounds of appeal 7, 8, 10, in part 25 and 45 concerns the alleged erroneous application of the burden and standard of proof for grounds excluding Mr. Ongwen's criminal liability. The appeals chamber finds that in the absence of a specific provision in the statute regulating the burden and the standard of proof with respect to grounds excluding criminal responsibility, the general provision of Article 66 of the statute apply. The appeals chamber considers that generally the prosecutor does not bear the burden per se to disprove each element of a ground excluding an accused's criminal responsibility. However, he or she must establish the guilt of the accused beyond reasonable doubt, even when the defense alleges a ground for excluding criminal responsibility. The appeals chamber also finds that when raising grounds purporting to exclude an accused's criminal responsibility, it is not enough to merely give notice of such an intention. The defense must also present evidence to substantiate its allegations. This so-called evidentiary burden on the part of the defense does not equate to a shift in the burden of proof as the prosecutor is not absolved of his or her burden to establish the elements of the crimes, such mental elements, and the modes of liability beyond reasonable doubt. Under ground of appeal 23, the defense has raised errors concerning the submission of evidence, challenging in particular the trial chamber's failure to explain the outcome of its evidentiary rulings either during the trial or in the conviction decision. In this respect, the appeals chamber notes that the trial chamber in this case considered the relevance and probative value of the evidence submitted at trial holistically when deciding on Mr. Ongwen's guilt or innocence. It was not per se erroneous for the trial chamber not to include in the conviction decision evidentiary rulings with respect to each item of evidence submitted at trial. However, the appeals chamber notes that in light of the requirement of a reasoned statement under Article 74(5) of the statute, the trial chamber must explain with sufficient clarity the basis of its determination. The appeals chamber considers that this duty to provide a reasoned statement on findings on the evidence is of particular significance when any party raises an issue concerning the relevance, probative value, or a potential prejudicial effect of a piece of evidence, especially when the opposing party raised an objection. Whether the trial chamber's failure to provide such reasoned statement amounts to an error must be assessed on a case-by-case basis. However, as the defense does not provide any example of alleged insufficiently reasoned rulings on evidence, the appeals chamber rejects ground of appeal 23. The defense has also raised other alleged evidentiary errors. For instance, errors in the trial chamber's assessment of intercept evidence, grounds of appeal 60, 72, and 73. In that regard, the defense submits a number of arguments concerning the trial chamber's assessment of intercept evidence. In particular, the defense submits that the trial chamber erred in making a general assessment of the reliability of logbooks based on a limited sample of intercepted communications. After a review of the pretrial chamber's findings and the evidence relied upon, the appeals chamber finds that the trial chamber assessed the reliability of logbooks by first providing its overall understanding of the voluminous intercept evidence submitted in this case, including the procedures employed to produce them, and further by referring to all the relevant parts of logbooks which reflect each intercepted communication it relied upon in the conviction decision. The appeals chamber also reviewed the trial chamber's use of intercept evidence in the specific charges such as persecution and sexual and gender-based crimes, and finds no error in its findings. Accordingly, the appeals chamber rejects grounds of appeal 72, 73, and 60. Alleged errors concerning the trial chamber's findings on Mr. Ongwen's individual criminal responsibility as indirect perpetrator and as indirect co-perpetrator. Under grounds of appeal 60, 64, 65, 68, 28 in part, 69, 70, and 74 to 86, the defense challenges some of the trial chamber's findings underpinning its determination that Mr. Ongwen is criminally responsible as an indirect perpetrator through an organized power apparatus for crimes committed in the context of the attacks on Lukodi IDP camp on or about 19 May 2004 and on the Abok IDP camp on or about 8 June 2004, and as an indirect co-perpetrator through an organized power apparatus for crimes committed, 1, in the context of the attacks in the Pajule IDP camp on or about 10 October 2003, and in the Odek camp on or about 29 April 2004, 2, for sexual and gender-based crimes not directly perpetrated by Mr. Ongwen, and 3, for the conscription of children under the age of 15 years and their use in armed hostilities. The appeals chamber notes that the arguments raised on appeal by the defense are to a large extent premised either on a misunderstanding or a disagreement with indirect perpetration and indirect co-perpetration as modes of liability provided for in Article 25(3)(a) of the statute. The appeals chamber therefore finds it important for this and future cases to set out the parameters of these modes of liability. The wording of Article 25(3)(a) of the statute is clear in that a person is considered a perpetrator when he or she, 1, directly commits a crime as an individual, direct perpetration, 2, commits a crime jointly with another person, co-perpetration, and 3, indirectly commits a crime, indirect co-perpetration. This is through other persons. While the direct perpetrators are those who physically execute the elements of the crimes, indirect perpetrators have control over the crime through controlling the actions of the direct perpetrators. In such cases, the direct perpetrators are instruments used for the commission of crimes. Generally, indirect perpetrators control the actions of the direct perpetrators in different ways, including when the direct perpetrator is not responsible. For example, because he or she is a minor, when the direct perpetrator is mentally disabled, or when the direct perpetrator is coerced, and through controlling their will through the use of an organized power structure. Whether an indirect perpetrator retains control over the actions of the physical perpetrators by virtue of controlling their will through the functioning of an organized hierarchical organization is a factual consideration. Consequently, the use of an organized power apparatus is not a legal requirement for establishing this specific mode of responsibility. Generally, the following features of an organized power apparatus may be of assistance in determining whether the indirect perpetrator retain control over the crimes by virtue of controlling the will of the physical perpetrators. The hierarchical organization of the apparatus its functional automatism, the replaceable nature of its members, and the fact that the criminal acts of the direct perpetrator are to the benefit of the organization. Therefore, in an organized power apparatus, typically those at the top of the organization retain functional control over the crimes committed, and the low-level members are interchangeable, let's say fungible. As to the proximity or remoteness of the indirect perpetrator to the criminal act, it is correct that as a general rule, in cases of direct perpetration, the further removed the person is from the criminal act, the more he or she is pushed to the margins of the events and excluded from the control over the acts. However, in cases of indirect perpetration, through the use of an organized power apparatus, the converse is generally true. In such cases, the loss of proximity to the act is compensated by an increasing degree of organizational control by the leadership positions in the apparatus. In this case, the defense appears to question the existence of indirect co-perpetration as a mode of liability under the statute. The appeals chamber notes that indirect co-perpetration constitutes an integrated mode of liability provided for in the statute that combines the constitutive elements of indirect perpetration and co-perpetration, and is, therefore, compatible with the principle of legality and the rights of the accused. The main elements of indirect co-perpetration are: 1, the control over the crime by indirect co-perpetrators, which in cases of the commission through an organized power apparatus occurs by virtue of controlling the will of the direct perpetrators through the automatic functioning of the apparatus. And 2, the existence of an agreement or common plan between those who carry out the elements of the crime through another individual or other individuals, including when those persons form part of an organized power apparatus. Accordingly, the defense's arguments that are premised either on a misunderstanding or a disagreement with indirect perpetration and indirect co-perpetration as modes of liability provided for in Article 25(3)(a) of the statute are rejected. The defense also alleges under grounds of appeal 60, 69, 70, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, and 86, several errors in the factual findings regarding the structure of the LRA. Mr. Ongwen's control over the crimes, the required mens rea, the common plans, the age of determination of the children conscripted and used in the hostilities, and the trial chamber's assessment of the evidence. In particular, the defense alleges that the trial chamber incorrectly assessed the evidence provided by several prosecution witnesses, failed to rely on documentary evidence submitted by the defense, failed to properly assess intercept evidence, that its conclusions regarding Mr. Ongwen's degree of involvement in the attacks of the 4 camps and its rejection of the likelihood of civilian deaths by crossfire were unreasonable, that it failed to consider that the policy of conscripting children below the age of 15 years predates the time frame relevant to the charges, and that it failed to consider that Mr. Ongwen only became commander on Senior Brigade on 4th March 2004. Given the number of factual errors alleged, I will summarize the Appeals Chamber determination on one of the challenges brought by the defense under grounds of appeal 60 and 70. This is done merely to illustrate the approach that the Appeals Chamber has taken when addressing the numerous alleged factual errors raised by the defense. With regard to the trial chamber's finding that Mr. Ongwen ordered the attack on Odek IDP camp, the defense admits that it is possible to make literal interpretation of the evidence elicited from witnesses P0054, P0264, P0142, P0314, P0340, P0372, and P0314. That the instructions primarily related to the collecting food, as there was a genuine hunger problem at the time. Contrary to the defense's argument, the trial chamber did not find that the witnesses contradicted each other on the point or that their evidence was otherwise inconsistent. It considered that the evidence before it justified and necessitated the finding that Mr. Ongwen, as well as other commanders, ordered LRA fighters to target everyone they find at Odek, including civilians, noting that this is plainly the context of the testimony of P0205 and P0410, who stated, respectively, that the order was to destroy Odek and to exterminate everything, and who are corroborated by P0054, and recalling that there is consistent evidence from multiple witnesses that the orders included looting food and abducting civilians. With respect to the instruction to collect food, the trial chamber recalled the testimony of P0340 as to the meaning of this expression. The witness stated that when you go there, you have to fight, you have to shoot at them, and they shoot at you because they are the people who protect that food. And further indicated that collecting food means that when we reached there, other people went to the barracks and other people went to the camp. From these passages, it is clear that the trial chamber's finding was not based on an impermissible inference that fails to reflect the evidence on trial record as suggested by the defense. Rather, it was supported by the evidence on the record. The appeals chamber notes that P0142, P0314, P0340, and P0372 confirmed that the order involved the looting of food. Furthermore, the trial chamber noted that P0314's mention of an instruction from Mr. Ongwen to abduct children. As the trial chamber correctly found, this evidence is consistent with that provided by P0410, P0205, P0054, and P0264. Based on the foregoing, the appeals chamber considers that the defense fails to identify any error in the trial chamber's finding that the evidence before it justifies and necessitates the finding that Mr. Ongwen, as well as other commanders, ordered LRA fighters to target everyone they find at ODEC, including civilians. The defense's argument is accordingly rejected. In relation to all the remaining arguments alleging errors for reasons fully set out in the judgment, the appeals chamber considers that the defense fails to identify any error in the trial chamber's reasoning and conclusions. Often repeating arguments raised before the trial chamber without disclosing any error in the trial chamber's disposition thereof. Therefore, the appeals chamber rejects grounds of appeal 60, 64, 65, 68, 28 in part, 69, 70, and 74 to 86. The appeals chamber concludes that the defense has not demonstrated any error in the trial chamber's finding of Mr. Ongwen's individual criminal responsibility as an indirect perpetrator and indirect co-perpetrator for crimes committed in the course of the attacks on the 4 IDP camps and for the conscription and use in hostilities of children below the age of 15 years. Alleged errors concerning sexual and gender-based crimes, hereinafter AGBC. Under grounds of appeal 66, 87 to 90, the defense challenges a number of the trial chamber's findings underpinning Mr. Ongwen's conviction of sexual and gender-based crimes, including the crime of forced marriage as a form of other inhuman acts and forced pregnancy. Under grounds of appeal 90 and 66 in part, the defense submits that forced marriage is not a crime under the statute and that the trial chamber's legal interpretation of forced marriage violates the principle of nullum crimen sine lege. The defense also submits that the facts of the present case do not support the trial chamber's finding that Mr. Ongwen's conduct amounts to forced marriage as a form of other inhuman act under Article 7(1)k of the statute. For the reasons that are fully set out in the judgment, the appeals chamber finds that convicting an accused of forced marriage as a form of other inhuman acts under Article 7(1)k of the statute is non ultra vires and does not violate the principle of nullum crimen sine lege. In this regard, the appeals chamber notes that Article 7(1)k of the statute provides for the category of crimes called other inhuman acts, which is designed to criminalize an act that does not specifically qualify as any of the other crimes under Article 7(1) of the statute. The appeals chamber finds that the scope of other inhuman acts as prescribed under Article 7(1)k of the statute and the elements of the crimes is sufficiently clear and precise to satisfy the principle of nullum crimen sine lege. In addition, since it is an open provision, meaning that different types of conduct may amount to other inhuman acts as long as they satisfy the elements of Article 7(1)k of the statute. The appeals chamber considers that in order to determine whether a specific conduct may qualify as a form of other inhuman acts, a chamber may have recourse to any relevant international instruments such as conventions and treaties. The Appeal Chamber also concurs with the Trial Chamber's finding that the central element of forced marriage is the imposition of conjugal union on the resulting spousal status of the victim. In this regard, the Appeals Chamber notes that the notion of conjugal union is associated with the imposition of duties and expectations generally associated with marriage, which may be established on the facts of the case. After a careful review of the Trial Chamber's findings and the evidence relied upon, the Appeals Chamber concludes that the Trial Chamber did not err by convicting Mr. Ongwen of forced marriage as a form of other inhuman acts, pursuant Article 7.1k of the statute. Under ground of Appeal 88, the defense challenges the Trial Chamber's finding that the crime of forced pregnancy is grounded in the woman's right to personal and reproductive autonomy and the right to family. The defense also submits that the Trial Chamber failed to consider whether its interpretation of these crimes affect the national law of Uganda on abortion, which in its view is required under Article 7.2f of the statute. Furthermore, the defense challenges the Trial Chamber's factual findings concerning forced pregnancy. For the reasons that are fully set out in the judgment, the Appeals Chamber finds that the crime of forced pregnancy seeks to protect, among others, the woman's reproductive health and autonomy and the right to family planning. The Appeals Chamber, therefore, finds no error in the Trial Chamber's finding with respect to the protected interest of forced pregnancy. Regarding the defense's argument that the Trial Chamber failed to consider the national law of Uganda on abortion in accordance with Article 7.2f of the statute, the Appeals Chamber finds that this provision was inserted to alleviate the concerns raised by some states that forced pregnancy provision might be interpreted as interfering with the state's approach to abortion. The Appeals Chamber concurs with the Trial Chamber that Article 7.2f of the statute does not impose a new element to the crime of forced pregnancy. Therefore, the Appeals Chamber concludes that the Trial Chamber was not required to consider Ugandan law on abortion in its assessment of this crime. Moreover, after a careful review of the evidence underlying the Trial Chamber's factual findings, the Appeals Chamber finds that the defense has not shown any error in the Trial Chamber's factual findings on forced pregnancy. In addition, under grounds of Appeal 87, 89, and 66 in part, the defense challenges the Trial Chamber's findings that Mr. Ongwen was one of the commanders who developed and implemented the LRA policy on abduction and abuse of civilian women and girls. After a careful review of the Trial Chamber's findings and the evidence relied upon, the Appeals Chamber finds that the Trial Chamber was reasonable in finding that Mr. Ongwen was among the persons who helped define and through their actions over a protracted period sustain the system of abduction and victimization of civilian women and girls in the LRA, and that his role within the CENIA was crucial and indispensable. The appeals chamber, therefore, rejects the defense's argument under grounds of appeal 87, 89, and 66 in part. Alleged errors regarding grounds for excluding criminal responsibility. At trial, the defense alleged two grounds for excluding Mr. Ongwen's criminal responsibility, namely, that he suffered from a mental disease or disorder during the period relevant to the charges and that he committed the crimes under duress. The trial chamber rejected the ground for excluding criminal responsibility by way of mental disease due to the lack of evidence which would corroborate a historical diagnosis and based on the expert opinion of mental health professionals who did not identify any mental disease or defect in Mr. Ongwen during the period of the charges. Likewise, the trial chamber rejected the ground for excluding criminal responsibility by way of duress on the basis that there was no evidence at all to hold that Mr. Ongwen was subjected to a threat or imminent death or imminent or continuing serious bodily harm to himself or another person at the time of his conduct underlying the charged crimes. Consequently, the trial chamber found that Mr. Ongwen's guilt had been established beyond any reasonable doubt. On appeal, the defense challenges these findings of the trial chamber, which the appeal will address in turn. With respect to the ground of excluding criminal responsibility by way of mental disease or defect, the defense raises four main arguments under several grounds of appeal. First, it argues that the trial chamber erred in its assessment of the reliability of the evidence of mental health experts called by the defense. Second, the defense argues that the trial chamber erred in failing to rely on the evidence of the court-appointed expert, Professor de Jong, for its assessments. Third, the defense contends that the trial chamber erred by disregarding cultural factors when assessing Mr. Ongwen's mental health. Fourth, the defense argues that the trial chamber erred in its assessment of the evidence of Dr. Abo, a prosecution mental health expert. As to the first argument, the defense essentially takes issue with the trial chamber's findings concerning the methodology employed by the defense's mental health expert, who found that at the time material to the charges, Mr. Ongwen suffered from numerous mental disorders, such as severe depressive illness, post-traumatic stress disorder, and dissociative disorder. For the reasons fully explained in the judgment, the appeals chamber finds that the trial chamber did not err in concluding that it could not rely on the defense experts' evidence, given concerns it had over the defense experts' failure, inter alia, 1, to apply scientifically valid methods, 2, to take into account other sources of international information about Mr. Ongwen which were readily available to them, and 3, to properly test for malingering in Mr. Ongwen. Moreover, the appeals chamber finds no error in the trial chamber's assessment of contradictions in the evidence of the defense experts, in particular contradictions between the various statements and observations made, or between such statements and observations and the conclusions finally drawn. Therefore, the Appeals Chamber confirms the Trial Chamber's findings concerning the methodology and the consequent unreliability of the evidence of the defense's mental health experts. As to the second argument, the defense argues that the trial chamber erred in concluding that the observations of the court-appointed expert Professor de Jong had no relevance for its assessment as to whether Mr. Ongwen suffered from mental disease at the relevant time. In particular, the defense contends that Professor de Jong's observations concerning Mr. Ongwen's clinical history dating back to his childhood and his cultural context were significant. As explained in more detail in the judgment, the Appeals Chamber is not persuaded by this argument given the distinct purpose for which Professor de Jong's observations were requested, and the abundance of other evidence in the record concerning Mr. Ongwen's clinical and social history, dating back to his childhood and his cultural context, which were discussed at length by other experts, including the defense's own mental health experts. The Appeals Chamber thus rejects this argument and confirms that the trial chamber's decision not to rely on Professor de Jong's evidence for its assessment of whether Mr. Ongwen suffered from mental disease at the time relevant to the charged crimes. As to the third argument, the defense contends, inter alia, that the trial chamber disregarded cultural factors when assessing Mr. Ongwen's mental health. In particular, the defense argues that the evidence of Professor Musisi on the trauma suffered by the victimized population of northern Uganda and the resultant mental health problems documented amongst LRA traumatized individuals should not have been ignored by the trial chamber. Contrary to the defense's argument, the Appeals Chamber finds, for the reasons more fully elaborated on in the judgment, that it was reasonable for the trial chamber not to rely on the evidence of Professor Musisi, since he did not provide specific information in relation to whether Mr. Ongwen suffered from a mental disease during the charged period. As for the fourth argument, the defense argues in particular that Dr. Abo potentially exculpatory evidence relating to the adverse environment of the LRA and its impact on Mr. Ongwen's moral development and childlike personality, even as an adult, was disregarded by the trial chamber and resulted in the trial chamber's unreasonably ascribing criminal responsibility to Mr. Ongwen as an adult. The Appeals Chamber is not persuaded by these arguments. First, the Appeals Chamber notes that Dr. Abo's evidence about the adverse environment within the LRA and its negative impact on the development of a child was not in dispute during the trial. Second, while Dr. Abo's holistic assessment of the evidence concerning Mr. Ongwen's childhood development included the impact of his abduction and his lack of control as an adolescent over the adverse environment within the LRA, she nevertheless acknowledged that these factors did not absolve Mr. Ongwen of criminal responsibility. As an adult, for the crimes charged, Indeed, the appeals chamber notes that her characterization of these factors as an important mitigating factors may be viewed as significant for the purposes of sentencing, but not for the trial chamber's determination as to whether Mr. Ongwen suffered from a mental disease at the time relevant to the charges. The appeals chamber considers that Dr. Abo's evidence concerning Mr. Ongwen's lack of control over the LRA environment as an adolescent was not exculpatory of his criminal responsibility for the crimes he was found to have committed as an adult. The appeals chamber concludes that the defense has not demonstrated any error that could warrant the appeal chamber's intervention in relation to the trial chamber's findings on mental disease as a ground for excluding criminal responsibility pursuant to Article 31(1)(a) of the statute. Accordingly, the appeals chamber finds no merit in the arguments raised and rejects grounds of appeal 19, 27, 29, 34, and 36 to 43. With respect to the ground for excluding criminal responsibility by way of duress, the defense challenges under several grounds of appeal a number of trial chambers' findings underpinning its conclusion that Mr. Ongwen was not subject to a threat of imminent death or continuing or imminent serious bodily harm at the time of his conduct underlying the charged crimes, and that therefore duress as a ground of excluding criminal responsibility pursuant Article 31(1)(d) of the statute was not applicable to him. In relation to the defense's challenge to the trial chamber's interpretation of duress, ground 44, the appeals chamber finds that the trial chamber properly interpreted Article 21(1)(d) of the statute, when it held that terms imminent and continuing refer to the nature of the threatened harm, and that the threatened harm in question is either to be killed immediately or to suffer serious bodily harm immediately or in an ongoing manner. The appeals chamber further considers that the timing of the materialization of the threat is one of the criteria to take into account when assessing the existence of a threat. Regardless of whether the threatened harm occurs immediately or a later point in time, for a person to be compelled to commit a crime under the jurisdiction of the court, the threat must be present and real at the time of the charged conduct. The appeals chamber also considers that the existence of a threat must be objectively assessed. Any prior experiences of an accused person that may have an impact on him or on her at the time relevant to the charges which do not satisfy the threshold required for excluding criminal responsibility of the accused under Article 31(1)(d) of the statute may nonetheless be relevant for the purposes of sentencing in the event of a conviction. The defense further challenges a number of factual findings which the trial chamber relied on to conclude that the defense of duress was not applicable to Mr. Ongwen. These include the findings, 1, of Mr. Ongwen's status in the LRA hierarchy and the applicability of the LRA disciplinary regime to him, mainly raised under grounds of appeal 46 and 48. 2. On Mr. Ongwen's abduction, indoctrination, and life and service in the LRA, grounds of appeal 26, 28, and 47. And 3. On the possibility of escaping from or otherwise leaving the LRA, grounds of appeal 52 to 54. And 4. On Joseph Kony's alleged spiritual powers, ground of appeal 55. As an example, among the several challenges raised under grounds of appeal 26, 28, and 47, the defense alleges that the trial chamber correctly considered the impact of the evidence on Mr. Ongwen's abduction, indoctrination, and life and service within the LRA from his childhood onwards, and the enduring impact of these experiences on his mental health and his free will as an adult. It would have reached a different conclusion, namely that the defense's pursuant Articles 31, 1A and D were applicable in the present case. In particular, the defense takes issue with the trial chamber's finding that in its assessment, the chamber focused on the situation of Mr. Ongwen as battalion and brigade commander during the period of the charges, and that Mr. Ongwen's childhood experience in LRA was not central to the issue. The appeals chamber first notes that the confirmed charges against Mr. Ongwen concerned the allegedly committed as an adult between 1st July 2002 and the 21st December 2005. Therefore, any findings about Mr. Ongwen's experiences prior to this period cannot in itself be determinative of the central issues of the case. In this context, the appeals chamber finds that it was not unreasonable for the trial chamber to consider that Mr. Ongwen's childhood experience in the LRA was not central to the issue. In any event, appeals chamber notes that the trial chamber did take into account evidence of Mr. Ongwen's early childhood. It considered, in particular, evidence about Mr. Ongwen's age and abduction and his childhood experiences in its holistic assessment of the evidence relevant to the ground for excluding criminal responsibility by way of mental disease or defect. Furthermore, at the end of its analysis on the applicability of Article 31, 1D of the statute, the trial chamber explicitly noted the defense's submissions emphasizing that Mr. Ongwen was himself a victim of crimes on account of his abduction at a young age by the LRA. The trial chamber recalled that it had duly considered the facts underlying these submissions and also noted the potential relevance of these facts to both grounds excluding criminal responsibility. While acknowledging that Mr. Ongwen has been abducted at a young age by the LRA, the trial chamber noted that the accused committed the relevant crimes when he was an adult, and importantly, that in any case, the fact of having been or being a victim of crimes does not constitute in and of itself a justification of any sort for the commission for similar or other crimes. In light of these considerations, the appeal chamber finds that the trial chamber did not disregard the evidence referred to by the defense, nor did it err in its determination to focus on the situation of Mr. Ongwen as battalion and brigade commander during the period of the charges, finding that his childhood experiences in the LRA was not central to the issue. Accordingly, the defense's arguments are rejected. As a further example, under ground of Appeal 55, the defense challenges the trial chamber's finding about Joseph Kony's purported spiritual powers and its effects on Mr. Ongwen. In particular, it submits that the trial chamber disregarded or failed to give due regard to relevant evidence, and that it erred in concluding that LRA spirituality is not a factor contributing to a threat pursuant to Article 31(1)(d) of the statute. The defense refers to the testimony of certain witnesses that was allegedly disregarded. The appeals chamber, as set out in more detail in the judgment, notes that the trial chamber in fact assessed evidence from a number of former LRA members who testified about the effect of LRA spiritualism on them, and found that while there was evidence that some persons did believe in the spiritual powers of Joseph Kony, the evidence consistently showed that for many persons who stayed in the LRA longer, their belief followed a pattern. It was stronger in the young and the new abductees, and then disappeared in those who stayed in the LRA longer. The trial chamber also noted that the LRA members with some experience in the organization did not generally believe that Joseph Kony possessed spiritual powers, and that there was no evidence indicating that the belief in Joseph Kony's purported spiritual powers played a role for Mr. Ongwen. In fact, it noted the evidence of Mr. Ongwen's defying Joseph Kony speaks clearly against any such influence. The trial chamber ultimately concluded that the issue of LRA spirituality was not a factor contributing to a threat relevant under Article 31(1)(d) of the statute. The appeals chamber finds, as explained in the judgment, that the defense fails to show that the trial chamber disregarded relevant evidence, nor does it show any error in the trial chamber's approach and conclusions. Its arguments are therefore rejected. Furthermore, for the reasons set out in the judgment, the appeals chamber rejects all the remaining arguments raised and accordingly rejects grounds 26, 28 in part, 44, 46 to 26 to 56, 58 and 60 to 63 of the appeal. The appeals chamber concludes that the defense has not demonstrated any error in relation to the trial chamber's finding on duress as a ground of excluding criminal responsibility pursuant Article 31(1)(d) of the statute. Alleged errors regarding cumulative convictions. Finally, the defense challenges the trial chamber's findings regarding cumulative convictions under grounds of appeal 20, 21, and 22. First, the defense argues that the trial chamber erred in rejecting its contention on the relevance of Article 20 of the statute in its assessment of cumulative convictions. The appeals chamber finds that the trial chamber correctly determined that the ne bis in idem principle, as formulated in Article 21 of the statute, serves to prevent a retrial of a person who has been convicted or acquitted on the basis of the same conduct before this court. It follows that contrary to the defense's contention, this provision is not concerned with the question of whether a trial chamber can impose cumulative convictions on a person for the same underlying conduct in the same trial. With respect to the test applicable to cumulative convictions, the defense contends that the trial chamber correctly adopted a conduct-based approach, but misapplied it in relation to some specific crimes, such as the crime against humanity of forced marriage as a form of other inhuman acts. By reference to the language in the Bemba et al. Appeal judgment, the defense identifies the principle of speciality, consumptions, and subsidiarity as forming the core analysis of concurrences in civil law system. The appeals chamber considers that the test for cumulative convictions finds its rationale in the need to reflect the full culpability of an accused person, given that each provision, which has a materially distinct elements, protects different legal interests. What the legal interests protected by each crime are can only be discerned by reference to the elements of the specific crime. If these elements require proof of a fact not required by the other, cumulative convictions are permissible. Any remaining concerns arising from overlapping facts can be addressed in the determination of the sentence. The appeals chamber considers that this approach strikes a careful balance between the need to reflect the full culpability of an accused person while safeguarding his or her rights and ensuring that the person is not being unlawfully punished. The appeals chamber also rejects the defense's allegation that war crimes and crimes against humanity based on the same underlying conduct are impermissible concurrences. As the trial chamber correctly stated, in the conviction decision, crimes against humanity and war crimes reflect, partly, different forms of criminality, in that they complement, in terms of protected interests, the incrimination of the individual specific crimes, which in turn are therefore distinct depending on the relevant contextual elements. For instance, in relation to murder, both as a crime against humanity and as a war crime, while some of the legal interests protected may coincide, e.g. the right to life, the protected interests discerned from the contextual elements do reflect different forms of criminality, and consequently distinct crimes. As explained in the determination of Ground of Appeal 20, the legal interests protected by a given criminal provision can only be discerned by reference to the elements of the crimes. Furthermore, the appeals chamber rejects the defense's claim that cumulative convictions for the crimes of rape and sexual slavery and for the crimes of forced marriage as a form of other inhuman acts and sexual slavery are not permissible. As explained in the judgment, these crimes have materially distinct elements resulting from the fact that they protect different interests. The appeals chamber considers that while the protected interests may overlap to a certain degree, the fundamental nature of the crime of sexual slavery is reducing a person to a servile status and depriving him or her of his or her liberty and sexual autonomy. While for the crime of rape, it is the invasion of sexual nature of a person's body and the attack on his or her sexual autonomy. In addition, the interest protected by forced marriage as a form of other inhuman acts is not necessarily violence against physical integrity and deprivation of liberty, but crucially, a person's right to freely choose one's spouse and consensually establish a family. Conclusion. In concluding the summary of this judgment, and given that the relevant findings of the trial chamber have been confirmed, the appeals chamber wishes to recognize the extreme suffering experienced by the victims of the crimes committed by Mr. Ongwen during the time relevant to the charges. I will repeat this in French. En concluant la lecture du résumé de l'arrêt rendu ce jour, et étant donné que les conclusions pertinentes de la Chambre de première instance ont été confirmées, la Chambre d'appel tient à reconnaître les souffrances extrêmes qu'ont endurées les victimes des crimes commis par Dominique Ongwen durant la période visée par les charges. Appropriate relief. For the reasons set out in detail in the judgment, the appeals chamber rejects all the defense's grounds of appeal and confirms unanimously the conviction decision. This concludes the delivery of its judgment with respect to the appeal against the conviction decision. We shall now adjourn until 14:30 for the delivery of the judgment on the appeal against the sentencing decision.
All rise, we will